In this video, we'll be covering both wills and trusts for our highly tested topics guide for the MEE. So first things first, let's talk about frequency and what you can expect in a wills and or trusts question. So wills and trusts are often tested separately on the MEE. So it's more likely than not you'll see just a wills question or just a trusts question. And in fact, in most bar exam administrations, it's one or the other. And what I mean by that is you normally don't see wills tested in a question and trusts. It tends to be one or the other. And usually they're not combined. And again, I said usually, and that's because there are exceptions to the rule. Like in 2017, there was a question that tested both wills and trusts together, but that's not very common. And in the past, they've also tested wills crossed over with conflict of laws. It's not super common for that to occur, but it's definitely something that should be on your radar as possible. So before we move away from these basics, just a few other things that I want to point out. The National Conference of Bar Examiners often refers to wills as decedent's estates. So if you see that, you know they're discussing wills and wills principles. As it relates to trusts, they refer to trusts as trusts and future interests. And this is because it's not uncommon for them to write a trust question that tests something like class gifts and the future interests that we see in those gifts. So many examinees, while preparing for the bar, get that type of information when they learn real property. So I'd like to bring this to your attention. So if you're practicing a trust question and you see class gifts or a future interest issue tested, you're not surprised. So you don't have to learn that information twice, whether you're learning it in the context of real property and or trusts. Know that issues like class gifts and future interest can show up in trust questions. So turning to those highly tested topics within these subjects, first, let's tackle wills together. Then we'll segue over to trusts, and then we'll talk about some basic tips. So as it relates to our highly tested topics here in the world of wills, one topic that should be on your radar is intestacy or intestate succession. That's just a really fancy way to articulate that someone has died without a will, or they've died with an incomplete will, meaning maybe they have a will that's valid, but it doesn't dispose of their whole estate. We say when this occurs, the person has died intestate, or we need to turn to the laws of intestacy to determine who gets the decedent's assets. So if the decedent's spouse and parents do not survive the testator, then usually the decedent's assets go to their kids. And there are different schemes to figure out, how much goes to each, child or the decedent's child's issue. And the first scheme is what we refer to as per capita at each generation. And the way I think of this is that people at each generational level are treated equally. So the way you figure out a per capita at each generation issue is you always find the first generation where someone is alive and you hand out assets or a share of assets at that generational line. Then for those people that have predeceased the decedent at that generational line but left behind issue, we combine their shares and then divide it up equally at the next generational line. So that's what I mean when we say people at each generation here share equally. Compare that to the second scheme, which is per capita with representation, sometimes referred to as modern pars derbies. This approach is almost identical to the one we just discussed, but instead of dividing up assets equally at each generation, it doesn't do that. So you would first still find a generation where there's someone alive, and you would hand out a share of assets to each such living person and each predeceased person who's left behind issue. But instead of combining those shares of the predeceased together and dividing it up equally at the next generational line, you don't. If someone died but left behind a child, their child simply takes their share. So we're not as concerned with each generation sharing equally. That's not the focus with modern pars derbies. The other thing they really like to test in the world of wills is the validity of a will. So most states say that to have a valid will, it needs to be in writing, it needs to be signed by your testator and witnessed by 2 people. Also, to have a valid will, the person needs to be 18 or older and have the intent to create a will. So if you see a valid will or something you think might be a valid will on the MEE, discuss those basic elements. Now, if you have those elements memorized and you know that the will in question is not valid, do yourself a favor and connect the dots for the grader. You still want to articulate those elements, but then analyze them and explain to the grader why they're not present. Before you reach a conclusion, always go on to discussing holographic wills. About half of the states recognize holographic wills. You could essentially define a holographic will as an unwitnessed will. So in other words, it's in writing, it's signed, it's dated by the testator, and the material portions are in the testator's hand. That last requirement is required by most jurisdictions that recognize holographic wills. And if you still don't have a will after analyzing holographic wills, it's good to know that under the UPC, they have what we call the dispensing power. It's this idea that the proponent of the document, if they can show the court that the testator intended the document in question to be their will by clear and convincing evidence, the court will probate it. Turning to revocation of a will, oftentimes they test revocation by physical act. So this means the person who executed their will literally did something physically to revoke their will. This could be that they executed a new will that revoked their first will, or they can have some sort of words of cancellation where they, cross out a bequest, or they write that a bequest is no longer valid. It's also good to know that divorce can revoke a will. So if I'm married to Bob and I execute a will today, leaving Bob all of my assets, but then we get divorced, the law just assumes that because we're divorced, I don't want to leave Bob everything. So always double check on the MEE that you have a valid divorce. Just because the parties filed for divorce does not mean they're divorced. So the will not be revoked until the divorce is finalized. And then our last highly tested issue within wills I want to discuss is the Slayer Statute. So what this is an individual who feloniously and intentionally kills a decedent cannot inherit from that decedent, which I think if you think about this from a common sense perspective, this makes sense. You shouldn't be able to kill someone so that you can inherit from them, right? You can't have your cake and eat it too. But Slayer statutes only apply if the murder or killing was intentional. So always double check on your fact pattern, what type of killing was it? And this is because we have a little MEE tip for you. Most of the time when they test the Slayer statute, it's not applicable. In other words, usually the killing in your fact pattern is not felonious and intentional. It's usually accidental, and therefore the Slayer statute doesn't kick in. Now turning to some of our highly tested issues within the world of trusts. So the first thing to have on your radar is trust validity. In order to have a valid trust, you need 3 basic things. And what we find is that the answers to our MEE questions here are pretty basic, where most commercial bar prep courses teach this in a very convoluted fashion. So I want you to just focus on the basics and you'll do quite well. So the basic requirements here for trust validity is that you need a trustee, you need a beneficiary, and you need trust property. Now, trustees are going to manage the trust property and hold it for the benefit of the beneficiaries. Trusts will not fail for lack of a specifically named trustee. Courts are happy to appoint one. Now, the trust beneficiaries have to be definite and ascertainable. We need to know who they are. And the same person can't be both the sole trustee and the sole beneficiary, or the trust is said to collapse. For that last requirement of trust property, we need the trust property to be identifiable. We need to know what we're holding in trust and what that trustee is managing for the benefit of those beneficiaries. The other highly tested topic within the world of trusts is revocability. If a trust is revocable, then this means your settlor, the person who creates the trust, can terminate it if all of the beneficiaries are in existence and agree. Now, once the settlor dies, irrevocable trusts can be terminated through unanimous consent from both the income beneficiaries and the remainder men. So everyone has to agree, And more importantly, there must be no material purpose yet to be achieved. So basically, everyone who has a say in this trust says we want it to terminate, we're okay with it terminating, and they show the court that there's really no reason to keep the trust going. And then the last thing I want to talk about in terms of highly tested topics within trusts is that you should be aware of different types of trusts. So a few things to have on your radar. First, pour-over wills. A pour-over will is when a will makes a gift to a trust. And these are valid so long as the trust is identified in the will and the terms of the trust are also found in another written instrument. Be aware of discretionary trusts. Discretionary trusts are kind of as they sound. It's where your trustee is given a lot of power or a lot of discretion to decide, when to make a distribution to the beneficiary and in how much. This means the trustee can't be forced to make a distribution to the beneficiary. Also be aware of support trusts. This is a kind of discretionary trust. This is where the trustee is supposed to be making disbursements for the beneficiary's support. So if something is deemed necessary for that beneficiary's support, then the trustee has to make that type of distribution. Also be aware of spendthrift trusts. Spendthrift trusts restrain both the voluntary and the involuntary transfer of a trust beneficiary's interest. This is a great way to protect trust property from a creditor of a beneficiary. Now, there are some favored creditors you should have on your radar. These guys, the favored creditors that I'm referring to, they can get their bills paid, but they can only reach what the beneficiary can reach. They can never reach more. So make sure you familiarize yourself with those types of discretionary trusts. The final type of trust to have on your radar is a charitable trust. So a charitable trust is created for a charitable purpose and for our large group of not readily identifiable people. Usually when they test charitable trusts, they're testing the common law doctrine of cypre. This is a situation or an issue when the charitable trust in question becomes unlawful, impracticable, or impossible to achieve, and someone asks the court to modify the trust in question. Cypre allows the court to make a modification so long as they find that settlor had general charitable intent and there is no alternative charity named. And what they'll do is they'll basically try to modify the trust, which usually means they're finding like a substitute charity to allow the trust to continue to move forward rather than it terminating. So now that we've covered some highly tested topics within both wills and trusts, I can't stress this next tip enough, which is to make sure you're familiar with wills and trusts vocab. I'm not going to read it all to you. I trust that you're following along with me here in our guide where we've listed a lot of the very important vocab for you, but you really want to make sure that you can read the fact patterns and understand the vocab that they're providing, but that you can also utilize it and use it in your answers. And you want to get in the habit of bolding it or italicizing it or underlining it and drawing that positive attention to it. My final tip for you is when you review these subjects, please don't just listen to your lecture. We find that a lot of commercial bar prep courses, while they teach, of course, wills and trusts, they don't often teach this material the way it's tested. So what I would urge you to do is listen to your lecture, study your materials, but also heavily focus and rely on past MEE questions and answers here. That way, you can use those past answers and those rule statements, and you can get a look at how they like to test these issues to make sure that you're understanding your lectures as best as you can. So for instance, to give you an example, many courses mix up per capita at each generation and per capita with representation. And that's a problem. If you were to call one scheme the other, you're going to reach the incorrect conclusion. So you want to make sure you're calling it what the NCBE calls it, because ultimately they're writing the answer key. So you want to make sure your answer lines up with theirs. Other issues that we see with commercial bar prep courses and how they test things tend to be with class gifts and future interests. This can get very complicated. There's, nothing that can't be stressed enough about that. These are complicated issues. And we find that oftentimes they're not taught the way these questions test it. So make sure you try your hand at some of these questions that test those more complicated issues so that you know how to answer them the way that the National Conference of Bar Examiners is expecting you to answer the question. So those are just a few examples. Again, we have a whole bunch of them listed for you in our guide, but I would summarize that tip is it's not enough to just listen to your lectures here. You really want to make sure you're using past answers in conjunction with that material so that you get a really good feel for how they're testing these issues. So that wraps up our discussion of highly tested topics and issues within wills and trusts.